Hey y'all, welcome back. This is going to be Unit 3C. So I think we have four cases here, and this is all about reproductive rights. So case one, of course, is Roe v. Wade from 1973. And this is a 7-2 affirmation of the lower court ruling. This was all the liberals and two of the conservative justices voted for Roe. Justice Blackmun delivers the majority opinion. All right, so the context here is that Texas had a law on the books which criminalizes abortion under any circumstances except for the purpose of saving the mother. Roe, which is an anonymous name, her name is actually Norma McCreevy. She's had a pretty interesting life from sort of bringing this case and winning her case to then becoming a mouthpiece for the anti-abortion movement. God damn it, just a second. Doing goddamn street cleaning. It's been going on for 2 days. It's frustrating me. Okay, anyway, I'm sorry. Um, so again, her name was Norma McCreevy. She was a single mother, and she became pregnant and didn't think that she could care for her child, and wanted an abortion. She won her case. Eventually, however, like I said, she became sort of a spokesperson for the anti-abortion movement and the Republicans. And then at the end of her life, she admitted that she was always pro abortion, but she had been sort of paid off by the far right. And it was so much money that she couldn't turn it down. And she regretted the last 20 or 30 years of her life. So it's a tough story. So if you're interested, there's a lot of information out there about her, but she's a very interesting woman. So anyway, she wanted an abortion. She makes a right to privacy claim under the First and the Fourth and the Fifth and the Ninth and the 14th Amendment, right? So you got to remember this is sort of an amalgamation of cases and touching on these little pieces of due process and right to right to speech and thought and religion and the right to not self-incriminate and so we pieced together this right to privacy that was never in the 10 Amendments or the Constitution. So she makes this claim. Texas's rebuttal basically is that abortion is medically dangerous, and the court just patently strikes this down. They're like, that's bullshit. It may have been dangerous in 1850, but first trimester abortions are far safer than live births at this point, even. So that's we're not even going to think about that argument. And then, Texas also says the state has a duty to protect prenatal rights. And so the ruling comes and they say the right to privacy, whether it be founded on the 14th Amendment's concept of personal liberty and restrictions upon state actions, or, as the district court determined, the Ninth Amendment's reservation of the rights of the people that are not enumerated in the Bill of Rights, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. Specific and direct harm medically diagnosable even in early pregnancy may be involved. Maternity or additional offspring may force upon the woman a distressful life and future. Psychological harm may be imminent. Mental and physical health may be taxed by childcare. There is also the distress associated with the unwanted child, and there is the problem of bringing the child into a family already unable, psychologically or otherwise, to take care of it. However, the state does have the right to legislate abortion after the quote compelling point of the end of the first trimester. And this compelling point is what the court and medical scientists have argued is viability, right? So this is the point wherein some children, a very small few, can survive outside of the womb if they're born extremely prematurely, right? Um, So they're not likely to survive, but they do have all the bodily functions to survive, like a brain, liver, kidneys, heart, etc. Right? And so this is the point where the court draws the line after like 12 to 14 weeks, basically. Then the state can start regulating abortions. All right, so case number 2, Planned Parenthood v. Danforth in 1986. This is a 5-4 affirmation of part of a lower court ruling and reversal of part of a lower court ruling. Okay, so, and Justice Blackmun delivers the majority opinion. So Missouri passes a law requiring women to sign a document of consent prior to an abortion, but no other medically procedure has this requirement in Missouri, right? So if you break your leg, you don't need consent to have your leg fixed, right? But you do have to have consent for an abortion. And not only do you have to have the mother's consent, you also have to have the father's consent. And so the Supreme Court rules that it is reasonable for Missouri to sort of put a standard in saying that you do need to have consent from the mother to operate an abortion. However, the father's consent is not constitutional. And the reasoning for this is that the mother carries most of the burden of the pregnancy, and therefore it is her bodily autonomy decision. And then finally, Missouri also had parental consent, where at least one parent had to sign for consent for an abortion for any young woman under the age of 18 who is not married. And again, the courts say, no, this is unconstitutional. States may not give parents, quote, an absolute and possibly arbitrary veto over the decision of the physician and his patient. All right, so we're sort of really specifying what we meant in the Roe decision here, right? So we're getting more and more specific to try and really specify what it means. All right, so case 3 is Bellotti v. Baird, or it's also called Bellotti 2. This is a 1977 case. It is a 9-1 decision. So I know this is weird because there's only nine justices, but one justice concurred in part and dissented in part. So it's kind of a unanimous decision with a little bit of an aside saying, okay, there's this little piece I don't really agree with. All right, so Justice Powell delivers the majority opinion. And the big quote at the beginning is that a child merely on account of his minority is not beyond the protection of the Constitution. And the ruling says, this is a big one, viewed together, our cases show that although children are generally protected by the same constitutional guarantees against governmental deprivations as are adults, the state is entitled to adjust its legal system to account for children's vulnerability and their needs for concern, sympathy, and parental attention. Second, the court has held that states validly may limit the freedom of children to choose for themselves in the making of important affirmative decisions with potentially serious consequences. During the formative years of childhood and adolescence, minors often lack experience, perspective, and judgments to recognize and avoid choices that could be detrimental to them. So they're saying, the state does have a little bit more power to regulate children than it does adults. The tradition of parental authority is not inconsistent with our tradition of individual liberty. Rather, the former is one of the basic presuppositions of the latter. Legal restrictions on minors, especially those supportive of the parental role, may be important to the child's chances for the full growth and maturity that make eventual participation in a free society meaningful and rewarding. There is no reason to believe that this would be so in the majority of cases where consent is withheld. But many parents hold strong views on the subject of abortion, and young pregnant minors, especially those living at home, are particularly vulnerable to their parents' efforts to obstruct both an abortion and their access to the court. It would be unrealistic, therefore, to assume that the mere existence of a legal right to seek relief in superior court provides an effective avenue of relief for some of those who need it most. We conclude that under state regulations such as that undertaken by Massachusetts, every minor must have the opportunity, if she so desires, to go directly to a court without first consulting or notifying her parents. If she satisfies the court that she is mature and well enough informed to make intelligently the abortion decision on her own, the court must authorize her to act without parental consultation or consent. If she fails to satisfy the court that she is competent to make this decision independently, she must be permitted to show that an abortion nevertheless would be in her best interests. If the court is persuaded that it is, the court must authorize the abortion. If, all things considered, the court determines that an abortion is in the minor's best interests, she is entitled to court authorization without any parental involvement. On the other hand, the court may deny the abortion request of an immature minor in the absence of parental consultation if it concludes that her best interests would be served thereby, or the court may, in such a case, defer decision until there is parental consent, in which the court may participate. But this is the full extent to which parental involvement may be required. For the reasons stated above, the constitutional right to seek an abortion may not be unduly burdened by state-imposed conditions upon initial access to court. So, if the child is intellectually mature enough, the court must give her access to abortion and cannot notify her parents. However, if the child is deemed to be too immature to make that decision on her own, then the courts can involve the parents. All right. Case 4, Akron versus Akron Health Center. All right, so this is where states start to make really specific laws to sort of limit abortion clinics, right? And so we'll talk about that in this case, and then especially in the next section. So this is Akron v. Akron Health Center in 1986. The vote is 6-3, affirmation in part and reversal in part of the lower court ruling. And Justice Powell delivers the majority opinion. All right, so there's 5 Akron ordinances that are being considered here. First, all abortions performed after the first trimester must be performed in a hospital, not an abortion clinic. 2, notification of and consent by parents before abortions may be performed on unmarried minors. So again, this touches on the case we just talked about. 3, requires that the attending physician make certain specified statements, so a legal statement you have to say as a physician, to the patient to ensure that the consent for an abortion is a truly informed consent. Number 4, a 24-hour waiting period must be maintained between the consent signature and the actual abortion operation. And number 5, requires that the fetal remains be disposed of in a humane and sanitary manner. Now, I'm not really sure what that means, and they say that one doesn't pass constitutional muster due to due process clause, but they didn't really go into it, so I'm confused about what that law entailed. Okay, but the other stuff we can talk about. So the ruling is, first, the hospital qualification cannot be enforced. And they say, by preventing the performance of simple D&E abortions in an appropriate non-hospital setting, Akron has imposed a heavy and unnecessary burden on women's access to a relatively inexpensive, otherwise accessible, and safe abortion. The effect of inhibiting the vast majority of abortions after the first 12 weeks, and therefore unreasonably infringes upon a woman's constitutional right to obtain abortion. All right, number 2, the doctor's statement of consent. Basically, they say here, this does not mean, however, that a state has unreviewable authority to decide what information a woman must be given before she chooses to have an abortion. It remains primarily the responsibility of the physician to ensure that appropriate information is conveyed to his patient depending on the particular circumstances. Danforth's recognition, the previous case, of the state's interest in ensuring that this information will be given will not justify abortion regulations designed to influence the woman's informed choice between abortion or childbirth. Viewing the city's regulation in this light, we believe that the law attempts to extend the state's interest in ensuring informed consent beyond possible limits, so they strike that as well. 3, the 24-hour waiting period, they also strike out. In accordance with the ethical standards of the profession, a physician will advise the patient to defer the abortion when he thinks this will be beneficial to her. But if a woman, after appropriate counseling, is prepared to give her written informed consent and proceed with the abortion, a state may not demand that she delay the effectuation of that decision. Okay, so some pretty huge cases. Um, and then the next time we'll be talking about the undue burden standard. All right, so thanks for being here and have a great day.